Friends, today we will discuss very significant topic pertaining to the government employees facing the departmental inquiries or the criminal prosecution. The question is whether such employees either facing the criminal prosecution or the disciplinary proceeding would be entitled to get promoted during the prosecution or the inquiry proceedings. This issue arises more often and ultimately litigations come to the court because the employees facing the departmental proceeding or the criminal proceedings are often denied the promotion or even consideration for the matter, and ultimately they are deprived of the right of promotion. In this regard, it would be interesting to see what exactly the legal position stands as explained by or laid down by apex court of this country. Dear friends, the government servant may be facing the departmental inquiry in respect of the major penalty proceeding or minor penalty proceeding. So, we will also discuss these two aspects as far as the disciplinary proceeding is concerned, and we will also discuss when the government servant is facing the criminal proceeding. Now, before we go into the subject, before we touch upon the legal aspect, let me tell you as to when it can be said that a government servant is actually facing such proceeding, whether criminal proceeding or the departmental proceeding. In the general parlance, we say that once an FIR is lodged against somebody, he is facing the criminal proceeding. But as far as this particular aspect in such cases is concerned, that is in respect of the government servant and particularly vis-a-vis their consideration for the promotion is concerned, then law is that the departmental proceeding or the criminal proceeding cannot be said to be pending unless the charge sheet has been served to the concerned employee. That means, now let us first deal with the criminal case, criminal prosecution. An employee or the government servant cannot be said to be facing the criminal prosecution unless the police has filed a charge sheet against him in the court of law, which means mere registration of FIR against him is not a pending prosecution against him. After the FIR has been lodged, the police carries out investigation in which it is found that there is material against him to prosecute him, and based upon such investigation, police ultimately files its final report, that is the challan, that is the charge sheet, and the court takes cognizance of the same on the same date. Then employee is said to be facing the criminal proceeding. After such charge sheet is filed against him in the court, the employee concerned is under the cloud, and then whether he is entitled to be promoted. Now, if FIR is lodged and police is yet to file such final report against him, that is charge sheet against him, and before that date, if the departmental promotional committee meets up and employees along with him, including him, are considered for the promotion, then in that case, it is as if there is nothing against him, and therefore in the normal course, he has to be promoted along with others. But after the date of filing the charge sheet against him, he is entitled only to be considered but not immediately promoted, because in such cases what is known as sealed court procedure is the legal principle. The department will have to follow or adopt the sealed cover procedure. Now, this sealed cover procedure means that such employee facing criminal case has to be considered along with others on the basis of his previous record, that is the ACRs of his immediately preceding years, his seniority, etc. And based upon that, the committee, that is the departmental promotional committee, will make recommendations whether he is fit or unfit. If departmental promotional committee finds him fit for the purpose of promotion, then also such recommendations will be kept in a sealed cover, and such sealed cover will be opened only after the conclusion of the criminal proceeding, that too when such criminal proceedings result into complete exoneration, that is acquittal. Now, this is the legal principle. Similarly, if an employee is facing a departmental proceeding, then it is important to see, in some cases, or nowadays in many cases, the employees may be kept under suspension when it is proposed that departmental proceeding has to be initiated against him. Then merely because he is suspended, he cannot be excluded. But when he is suspended, or even otherwise when he is not suspended, but he has been actually given charge sheet by his competent authority, then in such cases, once he receives the charge sheet, then it is said that he comes under the cloud, and then in that case, he will have to be only considered along with others. But the recommendations of the DPC, that is Departmental Promotional Committee, will have to be kept in the sealed cover, and such sealed cover shall be opened only after the conclusion of such departmental proceedings, that too when such proceedings ultimately result into clean sheet, that is ultimately employee is given a complete exoneration and nothing against him has been proved, and it doesn't result into imposition of any penalty, even a minor penalty for that purpose. Now, slightly different occasion also comes. In some cases, the employee might be given a minor penalty, and the law is that when the employee is to be punished with a minor penalty, no lengthy procedure of giving a charge sheet and then following the procedure is required. Therefore, in such cases, normally what is done is that he is given only a show cause notice, and he is called upon to make his defense by way of submission, by way of reply to the show cause notice, and after consideration of such reply to the show cause notice, he might be imposed with a minor penalty. Now, if such is the case, when the Departmental Promotional Committee meets, but prior to that, the employee concerned has been punished with the minor penalty like stoppage of an increment, for example, 1 year, 2 year, 3 year, whatever, then the period for which the increment has been stopped is the period of currency of the penalty. And in such cases, the promotion will not be effected from immediate date of the DPC or along with others, but such promotion will be given effect to only when the currency of the penalty comes to an end. That means in all such cases, the employee cannot be excluded from the consideration in the first place, but the promotion will depend whether the proceedings result into clean sheet or whether the proceeding result into imposition of any major penalty. Now, it may happen in certain cases that the inquiry proceeding might be initiated for imposition of major penalty, but ultimately it may result into minor penalty. So, in such cases, it is understandable that the employee will have to be given promotion if otherwise he is found fit by the DPC based upon his previous record and SCRs, etc. after the currency of such minor penalty expires. Dear friend, in this regard, there is a famous case. If you want to really go in depth to understand the issue, then I will recommend that you should read the case. That is the case of Union of India versus KV Janki Raman. This case began in a CAT, that is Central Administrative Tribunal, where the employees, certain employees who were not considered even for the promotion during the facing of the proceeding, and they challenged the provisions of some OM. Initially, there was OM of the Government of India, and the provisions of that OM were held unconstitutional by the CAT, and therefore the Government of India challenged that order of the CAT in the Supreme Court under 136 of the Indian Constitution, and Supreme Court upheld such finding of the CAT and clarified the position that in such cases, the employees cannot be excluded from the consideration, but the only thing is that the recommendation of the DPC will have to be kept in a sealed cover, and the sealed cover should be open only after the conclusion of the proceedings resulting into clean sheet or the acquittal or the exoneration. And they should, in such cases, then the employee is entitled to be given promotion with effect from the date on which he is otherwise entitled. That is the date on which his immediate colleague or his juniors might have been promoted, as if there is nothing against him and there was nothing against him, because ultimately the proceeding resulted into clean sheet. That is, his innocence has been upheld with the stamp of the authorities concerned. This is very important aspect pertaining to the employees who might be facing such cases either in criminal court or departmental proceeding, etc. Right to promotion is a fundamental right coming from Article 14 and 16 of the Indian Constitution, and therefore such a important right of fundamental right cannot be just kept in dark just because there is allegation either in criminal court or the departmental proceeding. We will stop here. I will try to continue to make such videos, and I think this is the video after a long gap because of the professional constraints. I was unable to make the videos on regular basis. Now again, let us see whether I could find time to make such videos. Till then, goodbye and namaste.